Hi, I'm Liane Jackson, senior law editor at Forbes, and I am joined by Jon-Jorge Aras, who is a legal expert and principal at Aras Law. Thank you for joining me, Jon-Jorge.
Thank you for having me today.
So today we are in the middle of a monumental and, as people like to say, unprecedented criminal case where former President Donald Trump is facing a 34-count indictment for falsifying business records. And opening statements began. Last week they chose the jury. That was also a tumultuous time, but we had opening statements that didn't last particularly long, about half an hour each. Can you tell us a little bit about the prosecution and what they laid out to the jury? Because they are setting the stage for the rest of this case. And they were talking about this being a case, not just a hush money trial, which is the term we keep hearing over and over, is a hush money case. But they want this to frame this as about illegal election interference and a criminal conspiracy. Can you talk a little bit more about that and what they told the jury?
Absolutely. So the prosecution today got the opportunity to explain their narrative and lay out their case and what they plan to prove throughout this process. And it really breaks down into two areas. The first area is the falsification of business records. That's the underlying alleged crime, which is a misdemeanor that they're alleging former President Trump did by recording entries of retainer payments to his attorney, Michael Cohen, as retainer payments, as opposed to payments specifically for Stormy Daniels. That's one part of it. The second part of it is more broad-ranging. It has to do with a criminal conspiracy that former President Trump conspired with the National Enquirer to go out and stop negative stories from being run against him, with the goal, ultimately, of interfering with the 2016 election. And that interference allegedly would have been to stop negative press from coming out that would be shielded from the public so they couldn't make ultimately an informed decision on the candidate, former President Trump. So it's broken down into two parts. The first part is fairly straightforward. The second part is a little bit more broad-ranging, and a conspiracy will have to involve, obviously, more than one individual. So it's going to have to be a minimum two people up to a larger group that agreed to commit a criminal act.
And their star witness, who we've heard a lot from in recent years, or a lot about, who spent time in prison himself, Michael Cohen, Donald Trump's former fixer, is key to the prosecution's case. And part of both the prosecution's opening statement and the defense opening statement was to either say, you have to believe what he says on the part of the prosecution, or listen to what he says. Listen carefully. It's not just about him and his credibility, but the evidence and the receipts that we have. And the defense is trying to definitely poke holes in Michael Cohen's credibility. He's been, allegedly lied about a variety of aspects, and that he, his career and his future hinges on going after Trump in various ways. This was the narrative that the defense attorneys also tried to put out there to poke holes in a star witness and who's crucial to this whole conspiracy, Michael Cohen, who allegedly paid Stormy Daniels $130,000 to try to keep her quiet. And that's at the crux of this case. Can you talk a little bit more about how the defense, and in any case like this, how important it is to try to poke holes in the credibility of witnesses that are crucial to the case?
Michael Cohen is a very interesting witness in this case because he has already gone to jail for making these payments, for perjuring himself in front of Congress, for having various tax problems, and essentially he has been muddied up a lot. And the defense's position is going to be that you cannot believe Michael Cohen. Michael Cohen is a known liar. He is a convicted perjurer who, in addition to that, has an agenda against former President Trump. He is not reliable. Now, what the prosecution is going to try to do is minimize the credibility issues and focus just on the bare basic facts. What did you do? When did you do it? How did you receive the payment? What did you advise? Anything that's related to strict facts, they're going to try to walk a narrow tightrope. Whereas the prosecution is going to the defense is going to paint a much broader narrative that this individual is to not be trusted under any circumstances. And that's going to go part and parcel with the defense's overall argument that former President Trump lacked knowledge of what was going on. He was endorsing checks, but he wasn't recording things. He really was a step away from the process. Now, in order to get to a conspiracy, the prosecution is going to have to prove that Trump did have knowledge of payments, that Trump did make agreements to cover things up, and that he did so specifically in advance of the 2016 election to shield that from the public, to not allow that to come to the forefront, because it may have affected the public's perception of him and ultimately whether or not he would be elected as president.
So it's really important for the prosecution to prove their case of what Trump did and didn't know and when he knew it, and in order to prove this conspiracy, to show that he directed the payments. Is that accurate? And also, what you mentioned, the other aspect of the case might be a misdemeanor, but what does he face if this conspiracy is proved by the prosecution ultimately?
So the one half of it, the misdemeanor, would be for the falsifying business records. What elevates this into a felony is that the business records were falsified in furtherance of another crime, which would be the election interference and the conspiracy to make that election interference. So that's what raises it a level. The defense's point of view is really a collateral attack. They're saying that former President Trump didn't have knowledge, and they're also saying that a payment for former President Trump to protect himself and to protect his family in connection with a non-disclosure agreement, which is what was given to Stormy Daniels, there's nothing illegal about that. This is a person that's allowed to protect their reputation against salacious allegations, and they're allowed to protect their family. So what the defense is really trying to do is create a bigger gap, so there's less of a nexus, so there's less of a connection between what happened with the payment, what happened with how it was recorded, and how everything was set up, whether that was through the National Enquirer or through Michael Cohen. They want to create a distance there. So a good defense attorney will not just hinge on one theory, although it's very important to have a narrative of the case. It's very important to have a story no matter what, regardless of the evidence, regardless of the testimony that's elicited. You need to have a narrative. What can people understand? People understand storytelling. So he does have his story laid out for the defense. And additionally, he is making sure to pick his spots where he can take the prosecution's case and use different arguments to undermine and dismantle it. The credibility of Michael Cohen is one aspect. Trump's knowledge or lack thereof, that's another aspect. And then finally, what the payment actually was for, whether that is in fact illegal at all, is another part of it. So it's really a collateral step-by-step attack by the defense on the prosecution's case.
They're saying this is about financial records, that Donald Trump has no control or responsibility of how finances are handled. You know, he's at the top and he has people doing these sorts of things. So it's incumbent and important that the defense creates the distance that you're talking about. Now, in terms of the idea that, you know, there was no cover up, he was handling this was just payments to a personal lawyer. How, based on what we've seen in the news, what we've heard, what the prosecution's laid out today, there's been a lot of that's been kept under lock and key. But what we've heard so far, what is your opinion of how airtight or what the prosecution has that they will be able to lay out during this case, the type of evidence that they have in store, and how strong that is?
I think a conspiracy charge is a difficult charge to put together. So on the one hand, they have the misdemeanor charge. That seems a little bit more straightforward. This was recorded as a certain type of payment when in fact it wasn't. That argument can be made in a vacuum with clear evidence and factual evidence that doesn't require a lot of credibility determinations or other determinations about what the witnesses are saying and the facts to support that, and maybe text messages or phone calls that might allude to making it seem like there was an agreement to undermine election laws federally and in New York State. The conspiracy case is going to rely on Michael Cohen testifying that former President Trump knew certain things, participated in certain things, that David Pecker of the National Enquirer will likely have to come out and say, former President Trump was aware, he was directing, he was operating. They're going to need individuals to come out and say the things, use the admissions that former President Trump may have made during this process to ultimately get to the end goal of finding him guilty of a conspiracy. It looks right now that it may be an upward hill battle. We don't know what the mountain of evidence looks like, or if there's no evidence. We don't really know what it looks like at this stage. But we do know that the defense's point of view is to minimize former President Trump's role as much as possible, to separate him as much as possible, and to negate the potential illegality of this payment and turn it into something else. This is a payment for a non-disclosure agreement. Nothing really to see here. The government and prosecution's case is far-flung, and it's going too far in making these allegations that there was, in fact, a conspiracy. So I do think that the prosecution has the burden of proof. They have to prove their case beyond a reasonable doubt, and they're going to have an upward hill battle putting everything together. And I say that without knowing today what the substance of all the evidence is and what it looks like. There may be clear text messages, there may be clear phone records, there may be clear emails. It's all possible. It could come out there. And we may even hear from former President Trump on the stand at some point, who may go up and say, I deny knowledge of being involved in this process.
Well, his attorneys from the beginning, in the opening statements, went out on a limb and said Donald Trump is innocent. He's innocent of all of these charges. So they immediately are on the not just defensive but offensive in terms of whether it's poking holes in the credibility of the star witnesses or just trying to project the narrative that's going to go forward throughout the trial. David Pecker, another star prosecution witness, former publisher of the National Enquirer, testified for a short while today after opening statements concluded, and he is again central to this case as well, because as you said, what could be interesting is we don't know what details the prosecution has right now to put forward their case, because Michael Cohen has in the past, during his criminal troubles and other instances, and even media interviews, has said there was never direct commentary from Trump to do something that might be considered illicit or illegal. He claimed that it was always maybe a nod or an understanding. And so crucial to proving their case is going to be actual nexus and evidence, as you say. David Pecker, was part of he was part of a catch and kill campaign where Stormy Daniels came to the National Enquirer with her story of an alleged affair with Donald Trump. And that's where this began to spiral in terms of whether it was a hush money payment, whether it was a non-disclosure. And that's where the semantics are going to change and where the case is going to hinge. What do you think about David Pecker's role in this case? And he is the first prosecution witness.
I think the prosecution wants to use David Pecker to start slowly introducing evidence. It's not like the star witness is coming up right away. They need to lay the foundation for their case. They need to take it step by step. And one way to take it step by step here is to get David Pecker on the stand to describe what he does. What was his role? What was his job? What did he know? What did he do? And interestingly enough, here they brought up his phone number and they asked him to confirm his phone number, which previews that maybe this phone number later comes up on cell phone records with texts or communications where certain agreements are made between individuals, where potentially someone, Michael Cohen, is texting him and saying, former President Trump wanted me to get back to you to do this and to take these steps to kill this story. I do think the prosecution's use of that term, catch and kill, is a smart use of terminology for their narrative because it paints a certain picture of what was going on here. It makes it seem nefarious. Catch and kill a story that you don't like. The prosecution, just like the defense, they need to tell a story. They need to put it out there in a way that makes sense to the jurors. That's a good slogan for them to go back to. And I think the reason they're starting with David Pecker is they're laying the foundation. What are we talking about here? We're talking about the National Enquirer and stories that were killed and that were blocked, or other positive stories that were promoted leading up to the 2016 election. So I think it makes perfect sense that the prosecution started at this juncture with David Pecker.
And he's back on the stand tomorrow. Some of the media observers during the trial said that today Trump was very attentive. He was looking around the gallery. He was looking frequently at his own attorney. What do we know about Todd Blanche, who is his defense attorney? He sort of had a revolving array of representation. Do you know anything about his background or how we expect him to go forward and his style at all?
Todd Blanche made a very interesting move. He was at a large law firm in New York City, which the name escapes me right at this moment, but he was at a large law firm working as a partner, and he was tapped by former President Trump to be his defense attorney. And I believe he left that practice to just do this on his own. So he staked his career on the defense of Donald Trump. So obviously Donald Trump has a lot of confidence in him. He's a seasoned attorney that has taken on very difficult cases that former President Trump is facing, not just because the cases themselves have difficult facts or the allegations are something that the prosecution may have the evidence to back up. It's a larger case than that. It's political. He has to implement strategies across the board that both balance being a defense attorney and trying to get a great result for his client. And I really think that the end goal here overall is to get Donald Trump to the 2024 election, to call off the other cases so they don't go forward, to minimize any ill effects of this case. You know, in his perfect world, former President Trump would be completely exonerated here and get absolutely against them. The prosecution's case would fail, but he could also mitigate it and get the charges reduced to a misdemeanor and put former President Trump in a position where he gets a brief probationary period, which I don't think would have any effect on his voting base. In fact, it may even bolster it and say this prosecution came for a big swing at the plate and they whiffed. So his attorney has a lot on his plate, and he's really staked his career saying, Donald Trump is my number one client, and I'm going to do everything in my power to represent him across these different criminal trials.
Yeah, it'll be very interesting to see how that plays out, especially as the cross-examination will likely start tomorrow. And of course, when they end up calling their case, whether they even call former President Trump to the stand. Is there anything I haven't asked you about how you expect this trial to play out, whether Trump himself may actually take the stand or not, or any other observations you have that I haven't asked you yet?
I think that the decision of whether former President Trump is going to take the stand is very much going to rely on the effectiveness of the cross-examination. If the cross-examination of the prosecution's witnesses goes well for the defense, then I believe the chances of putting former President Trump on the stand go down significantly. The judge did make a ruling that if former President Trump does take the stand, they're going to be able to talk about the E. Jean Carroll case. They're going to be able to talk about other settlements he made. This is not a Pandora's box that the defense team may want to open. Typically with a defense case, you want to keep it tight and narrow, and you want to limit other facts and potential evidence that may not be relevant to this case at all. You don't want your client getting painted with a broad brushstrokes of negative allegations that could then prejudice the jury or bias them and say, oh, well, in light of all this information in these other case with E. Jean Carroll, wow, that was a lot of money that Trump lost in that case. He doesn't seem like a great guy, and then use that to color their thinking specifically in this case. So I think that Judge Merchant's ruling is going to give the defense some pause. Usually when a defendant decides, okay, I am going to testify, it's not like it's a last gasp or that it's, a last ditch attempt to save your case, but it is highly risky. It has to be very measured and controlled. And most defense attorneys in a criminal trial are very wary of putting their client on the stand because it can open them up to a lot of questions. And they have an absolute Fifth Amendment right to not testify against themselves. And that's a powerful constitutionally protected right. And so you want to do the best you can going through cross-examination, minimizing the case, presenting your own evidence. It's not necessary in most criminal cases to put the defendant on the stand. So I think that's something to keep an eye on as this develops. And also I'd be keeping an eye on what evidence is actually coming to light. Are there text messages? Are there agreements? Are there phone logs? Are there emails? Documents can be very powerful form of evidence because they put things in black and white. And they put things in black and white that are hard to get away from and hard to deny. And then you could show that to the jury and say, ladies and gentlemen of the jury, there is no question that on so-and-so date, this email was sent between these three individuals who agreed that squashing the story would be a good thing for the 2016 election. We don't know whether that exists or not, but it's something to definitely keep an eye on.
Yeah, as you said, the actual documentary evidence and black and white rather than testimonies, what the jurors are going to be looking for, and of course, observers as well, and analysts. And to your point about putting Trump on the stand, he hasn't so far taken the stand in his civil cases. So it'll be really interesting to see if that has any advantage for him in his criminal case. But, you know, this is must-watch viewing for people. It's, of course, a critical case in our country right now. So I appreciate you taking the time to help us sort through the issues and analyze all the legal elements going on, because there's a lot. So thank you, Jon-Jorge, again for joining me for this.
Thank you. It's my pleasure, and it is a very interesting case. We'll see how things play out over the next 5 weeks.